My name is Ed Foley, and our law firm helps railroad workers injured on the job. Under Indiana law, we have what's known as a Tort Claims Notice Statute, and that statute requires you to provide notice to the governmental entity if you have a claim that you're asserting as a result of the negligence or careless conduct of the governmental entity. There's typically a 180-day notice requirement, and you have to provide specific information with that requirement. You have to list witnesses, you have to explain what happened, you have to explain the amount of damages that you've suffered and how much you're seeking. And it's important to remember for railroad workers who are employed by the South Shore, this statute comes into effect and requires you to provide this specific notification details to your employer. While there is a 3-year statute within which to file suit against the railroad, if you're dealing with the South Shore or some other governmental entity or political subdivision operating as a railroad, you've got to provide detailed notice to the railroad about your claim, and that has to occur typically within 180 days after the incident. So it's important to investigate these claims right away and to provide the specific notice requirements to the railroad, explaining your claim and explaining your damages so that you can make sure you preserve the claim, that you can then file suit later within that 3-year statute. So it's important to get on these claims right away, and if you need help in that, please give us a call.